Testing, testing. Okay, welcome to the Public Service Commission's administrative meeting for September 20th, 2023. We have minutes from our meeting of September 6th to be approved. I'll start with Commissioner Slushman.
Aye.
Commissioner Barbay.
Aye.
Commissioner Richard.
Aye.
I vote aye. I'll cut your mic, so.
He's in timeout this morning.
So, Mr. Executive Secretary.
Good morning, Mr. Chair. At the outset, we will be deferring items 17 through 22 to a future administrative meeting. On today's consent agenda, there are 8 items. Item number 1 is from Securus Technologies LLC, proposes an update to its refund language for its Advanced Connect and Securus Debit products. Item number 2 is Fusion Cloud Services LLC. Its notice of intent to discontinue the provision of certain legacy telecommunications services. Item 3 is from DSCI LLC. Its application to participate in certain financing arrangements. Item number 4 is from Power Brokers LLC. Its request to cancel its license to supply electricity or electric generation services in Maryland. Item number 5 is from Sandy Ridge Wind 2 LLC. Its application for authorization to participate as a renewable energy facility for the Maryland Renewable Energy Portfolio Standard Program. Item number 6 is from Delmarva Power and Light Company. Its revised tariff pages with revisions to its Type 2 SOS customers rates. Item number 7 is from Potomac Electric Power Company. Its revised tariff pages with revisions to its Type 2 SOS customers rates. And item number 8 is from Southern Maryland Electric Cooperative, Inc. Its revised tariff pages proposing to adjust its base standard offer service rates.
Okay, so regarding item 1, I move that we accept the tariff provisions for filing with an effective date of September 20, 2023. Commissioner Sushman.
Aye.
Commissioner Barbay.
Aye.
Commissioner Richard.
Aye.
I vote aye. Item 2, I move that we note the filing. Commissioner Sushman.
Aye.
Commissioner Barbay.
Aye.
Commissioner Richard.
Aye.
I vote aye. Item 3, I move that we note the filing.
Aye.
Commissioner Barbay.
Aye.
Commissioner Richard.
Aye.
I vote aye. Item 4, I move that we approve the cancellation request of Power Brokers LLC. Commissioner Sushman.
Aye.
Commissioner Barbay.
Aye.
Commissioner Richard.
Aye.
I vote aye. Item 5, I move that we approve the application and issue a renewable energy facility ID certification number. Secondly, that we direct the applicant to establish a REC account with the PJM GATS system within 30 days of the certification. And third, direct the applicant to notify the commission within 30 days if any information on the application has changed. Commissioner Sushman.
Aye.
Commissioner Barbay.
Aye.
Commissioner Richard.
Aye.
Can we take 6 through 8 together? Okay, so regarding items 6, 7, and 8, I move that we accept the tariff pages for the particular companies, Delmarva Power and Light, Potomac Electric Power Company, and Southern Maryland Electric Cooperative with an effective date of October 1, 2023. Commissioner Sushman.
Aye.
Commissioner Barbay.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Thank you, Mr. Chair. We'll move on to the administrative agenda. The first item is number 9, Boomerang Wireless LLC. Its notice of Lifeline Legacy Plan expiration.
Good morning, Mr. Chair and Commissioners. Alden Manka on behalf of staff. On July 19th, 2023, Boomerang Wireless LLC, doing business as N-Touch Wireless, notified the Commission that its Lifeline Legacy Plan will expire and all subscribers will be moved to the 1,000 bundled voice-free plan. The impetus for this transition of customers to the 1,000 bundled voice free plan is the January 18, 2022 acquisition of Boomerang by Via One Acquisition Company, LLC. This acquisition led to Boomerang using a different support platform for all of its new customers, as well as putting all new customers on the 1,000 bundled voice free plan. All current customers at that time kept their plan, which was renamed to the Lifeline Legacy Plan. Over time, it has become economically unviable to continue paying for this additional platform, leading Boomerang to transition all remaining Lifeline Legacy Plan customers to the 1,000 bundled voice free plan. And there are currently 7 customers remaining that need to be transitioned. Customers being transitioned to the new plan will still receive 1,000 voice minutes and 100 megabytes of data per month, but their texts per month will be reduced from unlimited to 500 texts per month. This plan still satisfies the requirements of Lifeline Voice Service, as only 1,000 voice minutes per month are required to be provided. However, if these customers being transitioned still want to receive unlimited texts per month, they have 3 options. They could either switch to a different Lifeline provider that does provide unlimited texts per month, or they could stay with Boomerang and pay $1 per month for unlimited texts, or apply for the Affordability Connectivity Program, which they will automatically qualify for as they qualify for Lifeline. Under the Affordability Connectivity and Lifeline program, they would receive unlimited calling, unlimited texts, 10 gigabytes of broadband data, and a free phone. Staff recommends that the Commission note the filing. Thank you, and I am available for questions.
So actually, let me turn to the Office of People's Counsel before, because I take it you're from the applicant, correct?
Correct, Mr. Chair. Yes, right.
So let me get the Office of People's Counsel first, and then I'll have you respond to both.
Good morning, Mr. Chairman, Commissioners. Juliana Bell, Deputy People's Counsel, here on behalf of the Office of People's Counsel. Mark Shebist, an Assistant People's Counsel with our office, worked on this matter cooperatively with staff and with the company, and we appreciate their cooperation. The company, as you're probably about to hear from, has submitted some language that satisfies OPC's concerns. OPC came to an agreement with the company on that language. It provides, we think, adequate notification to customers about the fact that they're going from a plan that has unlimited text to a 500 text limit. That was our concern about the filing, which I believe was initially a consent agenda item, that we wanted customers to have adequate notice. We believe that the revisions provide that notice, and we withdraw our request that the company lose its designation as an ETC designated carrier until complying. We believe it has.
Okay,
Thank you.
thank you. And have you just introduce yourself for the record?
Yes, Mr. Chair, Commissioners, I'm J. Andrew Gibson on behalf of Boomerang Wireless LLC. And as the staff has mentioned, we were able to work cooperatively with them in revising these notices to these 7 customers. All of them are receiving the notices, and they're being provided information about the different options that were discussed. And most of the customers have already transitioned to the bundled Lifeline and ACP plan. These, for whatever reason, these 7 have not. They've got the very basic plan. They have the option to keep the basic plan or to upgrade at no cost to them. But if they want to stay with the basic plan for the additional text, it's a $1 per month. They can choose to pay that or not, but their service will not be interrupted. And that is, that's where we are, and thank you for your consideration today.
Okay, so I had some questions about this, but I actually had a meeting with folks from staff who answered all the concerns I had about this. So any questions for any commissioners? So,
Maybe just one quick one. So, is there a default if you don't hear back from the 7 customers?
Yes, Commissioner, the default would be that they have to do nothing. Their service will automatically be upgraded to the new platform. They will have the same voice, the same data. They just have a 500 text limit. And if they reach that, they'll be notified they can obtain additional text by signing up for ACP or paying the $1 copay. That's the only difference.
Okay, and the ACP, is that what was termed the affordability?
That's correct.
Okay.
And that does include, at no cost to the subscriber, unlimited text and a lot of additional data as well.
Okay, and just curious if all 7 already, I guess, are eligible for the affordability plan.
That's correct.
Why wouldn't that be the default?
Well, there's a process through the FCC that subscribers have to sign up for that. They're automatically eligible, but they do have to complete the paperwork. And these 7 customers have not done that for whatever reason. This will give them an opportunity to do so should they elect to fill out that paperwork.
Okay, and is that part of the communications that just fill out this paperwork and nothing changes?
Correct. That's right.
So that's part of the communications.
Yes,
Okay,
sir.
thank you. Thank you, Mr. Chairman.
Okay, well, thanks for all the information. I move that we note the filing. We'll start with Commissioner Sushman.
Aye.
Commissioner Barve. Aye. Commissioner Richard.
Aye.
I vote aye.
Thank you.
Thank you very much.
Mr. Chair, item number 10 consists of tariff revisions from Southern Maryland Electric Cooperative, Inc.
Good morning, Mr. Chair and Commissioners. Anson Justy on behalf of staff. On August 11th, 2023, Southern Maryland Electric Cooperative, SMECO, filed an update to its customer enrollment and information process flow section of its tariff. The changes include indicating what information SMECO will provide to registered electricity suppliers upon request under COMAR 20.53.03.02, such as whether a customer is receiving or has recently received energy assistance and describing the required process to request that information. The filing is in response to Senate Bill 31 or House Bill 397, which became effective July 1st, 2023, and prohibits a third-party retail supplier from offering to provide electricity or gas to households receiving energy assistance through a program administered by the Office of Home Energy Programs, unless previously approved to do so by the Commission. The tariff language changes facilitate implementing this law. Staff and the cooperative agreed to grammatical edits for language clarity compared to the original filing. Staff recommends the Commission accept the tariff as revised by staff with an effective date of September 20th, 2023. Thank you.
Good morning, Chair Hoover, members of the Commission. Damon Krieger on behalf of Southern Maryland Electric Cooperative. Thanks to staff for its thoughtful analysis, and I'm here to answer any questions that the Commissioners may have.
Any questions? All right, so I move that we accept the tariff provisions for filing as revised by staff in its comments of September 13th, 2023, with an effective date of September 20th, 2023. Commissioner Sushman.
Aye.
Commissioner Barve. Aye. Commissioner Richard.
Aye.
I vote aye.
Thank you.
Mr. Chair, item number 11 is a request from Red Ball Residential Partners to qualify 2 multi-dwelling units as low and moderate income subscribers under the Community Solar Program.
Good morning, Chair and Commissioners. Kenneth Albert on behalf of staff. We have here with us John Fiastro at the other podium on behalf of the applicant. This item addresses a filing by Red Ball Residential Partners that asks the Commission to determine that 2 multi-dwelling units operated by Landex Properties, and those are the residences at Thayer Avenue and the residences at Autumn Wood, I'll refer to them as the Thayer Autumn Wood projects, qualify as a low and moderate income subscriber, LMI, as part of the Maryland Community Solar Program. Red Ball is a community solar subscriber organization, or SO, that works in coordination with a company named Arcadia. Effective May 2013, the owners of the 2 buildings participate in a low-income housing tax credit program that is administered by the U.S. Department of Housing and Urban Development, or HUD. Only low-income households qualify for this tax credit program. And the laws and the regs and the Commission's February 2020 policy statement set forth a bunch of criteria for qualifying as LMI. But we could not find what caused the delay in processing this is we had trouble finding a specific program that we could check the box for. But there is a provision in the regulations that says that if the program, the Commission can look at alternative criteria for qualifying a project as an LMI project. And in this instance, we have a federally administrated program under HUD that applies fairly strict income guidelines that ensure, in HUD's view, that this is low income. So for that reason, staff recommends that the commission determine that the 2 multi-dwelling units operated by Landex Properties qualify as an LMI subscriber as part of the Maryland Community Solar Program.
Yes, sir. Go ahead.
Mr. Chairman, members of the commission, John Fiastro here on behalf of Arcadia and Esso Red Bull. I'm here for any questions.
Any questions for any commissioners? Very good. Okay, so I move that we determine that the 2 multi-dwelling units operated by Landex Properties, the residents at Thayer Avenue and the residents at Autumn Wood, qualify as an LMI subscriber as part of the Maryland Community Solar Program. Commissioner Schlesman.
Aye.
Commissioner Barve.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Mr. Chair, item number 12 is a request from Lagore Bridge Solar Center LLC for an extension of its construction and operational deadlines under its Certificate of Public Convenience and Necessity.
Good morning, Mr. Chair and Commissioners. Harrison Scher on behalf of the Office of Staff Counsel. On August 25th, LaGorge Bridge Solar filed a request to extend the CPCN construction commencement operational deadlines for a 20 megawatt solar energy generating facility in Frederick County by 12 months. The project's located at the southern side of LaGorge Road along the northern and southern sides of Clyde Young Road in Frederick County. The project was tied up in litigation for more than 2 years after the CPCN was granted. Litigation was finally completely resolved in favor of LaGorge Bridge by an opinion of the Maryland Court of Special Appeals dated December 8th, 2022, which affirmed the grant of the CPCN to LaGorge Bridge. Since the litigation has been over, since litigation over the CPC ended, the company has been working diligently to move the project forward. In the last 7 months, LaGorge has updated its wetland delineation and Phase 1 environmental site assessment, completed a limited NEPA report, entered a scoping and estimating queue with First Energy to update the construction timeline and costs for interconnection, coordinated with USFWS and state agencies regarding threatened and endangered species, and commenced coordination with the Maryland Historical Trust to satisfy license conditions 19 to 20. LaGorge has also completed an updated Alta survey and hydrology study. The company has demonstrated good cause to grant the requested extensions. The litigation defending the CPCN caused delays in the project of over 2 years, and the company was reluctant to risk moving forward with the project with litigation ongoing, given the potential for an unfavorable court decision. The pace of the legal process was outside of the company's control. With the litigation finally resolved, the company appears to have made good faith efforts to complete the project. LaGorge Bridge asserts it is on pace to begin construction in Q3 of 2024, to be operational by the end of 2025. The project is requesting an extension of 12 months from the original deadlines to assure the project can move forward with completion. An SSTAT search shows they are in good standing. Staff recommends that the Commission modify Condition 4 of the CPCN to extend the construction commencement deadline to August 19, 2025, and the operational deadline to August 19, 2026.
Good morning, Mr. Chairman, Commissioners. Maggie Witherup on behalf of the applicant, Lagore Bridge Solar LLC. Thank you, staff, for their analysis and recommendation. I would point out that it's actually been more than 5 years since the first CPCN was granted to this project. As a few of you may remember, that original CPCN was reversed on appeal to the Court of Special Appeals. Now the Appellate Court of Maryland was sent back. This commission again granted a CPCN for the project, and the county appealed that for another 2 years before we got a final decision from the Court of Special Appeals affirming the grant of the CPCN to this project. We are requesting an extension of only 1 year, notwithstanding the fact that the litigation has delayed the project by more than 2 years. And with me today is Mr. Grant Matthews from the company, who is the Director of Development for Birch Creek Development, and he'd like to say a few words to the Commission.
Yeah, I just want to thank everybody for their time and analysis and sticking with us over the past few years while we go through this litigation. We are excited to have a couple projects here in Maryland bring some renewable energy, and we look forward to answering any questions that you might have. Thank you.
So, So, any questions from the commissioners? So, Commissioner Barbe.
Yes, a quick one. Who brought the lawsuit?
It was Frederick County, the county where the project is located. In this case, they intervened in the project in the CPCN proceedings before the public utility law judge. They were late in intervening. It was after the record had closed and the company had already agreed to licensing conditions with PPRP and staff. The PULJ did grant the county permission to intervene in the law in the CPCN proceedings, and
when was the initial filing of the lawsuit? Roughly.
It was not a separate lawsuit. It was an appeal from the grant of the CPCN.
Oh, I see.
So once they had intervened and been granted leave to intervene in the case, they were a party to the CPCN proceedings. They appealed from the original grant of the CPCN that went up to the Circuit Court and then Court of Special Appeals. It came back down, and then they appealed from the second grant of the CPCN, which again went up to the Circuit Court and the Court of Special Appeals.
Yeah, no climate crisis here. Thanks a lot.
Thank you very much.
Any other questions? Actually, I have one. Whereabouts in Frederick County is this?
It is along Clyde Young Road and Lagore Bridge Road.
But I guess just give me a sense of kind of where in Frederick County vis-a-vis Frederick City where this is. So.
I don't actually know. I've been there.
Yeah, I understand. So.
It's you'll see on the next item on the agenda that there's another project in a similar situation, and one of them is north of the city, 20, 30 minutes, and the other one is southwest.
Okay. All right. Okay. Any other questions? Okay. So with that, I move that we modify Condition 4 of the CPCN to extend the construction commencement deadline to August 19, 2025, and the operational deadline to August 19, 2026 for the Lagore Bridge Solar Center solar generating project. Commissioner Sussman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Mr. Chair, item number 13 is a similar request for an extension of CPCN deadlines from Biggs Ford Solar Center LLC.
Hello once again, Commissioners. Harrison Scher on behalf of staff. On August 25th, 2023, Biggs Ford Solar Center LLC filed a request to extend the CPCN construction commencement and operational deadlines for its 15-megawatt solar energy generating system project in Frederick County. An extension of 18 months is being requested. This project is located at the intersection of Briggsford Road and Dublin Road on the western edge of Walkersville in Frederick County. The project was tied up in litigation for more than 2 years after the CPCN was granted. The litigation was finally completely resolved in favor of Briggsford by an opinion of the Maryland Court of Special Appeals dated December 12, 2022, which affirmed the grant of the CPCN to Biggsford. Since the litigation has ended, the company has been working diligently to move the project forward. In the last 7 months, Biggsford has updated its wetland delineation and Phase 1 environmental site assessment, completed a limited NEPA report, entered a scoping and estimating queue with First Energy to update the construction timeline and cost for interconnection, coordinated with USFWS and state agencies regarding threatened and endangered species, and commenced coordination with the Maryland Historical Trust to satisfy license conditions 25, 27, and 28. The company has demonstrated good cause to grant the requested extensions. The litigation defending the CPCN caused delays in the project for over 2 years. The company was reluctant to risk moving forward with the project with litigation ongoing, given the potential for an unfavorable court decision. The pace of the legal process was outside of the company's control. With the litigation resolved, the company appears to have made good faith efforts to complete the project. Biggs Ford asserts it is on pace to begin construction at the beginning of 2024 and is requesting an extension of 18 months from the original deadlines to ensure the project can move forward to completion. The project is in good standing with the Department of Assessments and Taxation. And the staff recommends that Commission modify condition number 3 of the CPCN to extend the construction commencement deadline to May 24th, 2025, and the operational deadline to May 24th, 2026.
Good morning, Mr. Chairman, Commissioners. Maggie Witherup again on behalf of the applicant, Biggs Ford Solar Center LLC. I have one correction to staff's comments, and that is the company is on pace to begin construction in the third quarter of 2024, not the beginning of 2024. This was a situation where Frederick County did intervene in the proceedings before the public utility law judge. Due to the pace of the CPCN proceedings, the CPCN in this case was issued after the first CPCN was issued to Lagore Bridge, but before the second CPCN was issued to Lagore Bridge. Frederick County again appealed these decisions to the Circuit Court and Court of Special Appeals, and due to the way that the appellate courts work, they ended up being decided at almost the same time at the Court of Special Appeals. So the CPCN in this case was issued a little bit before the one in Lagore Bridge, so we're asking for an 18-month extension instead of a full 2-year extension, which again is less than the amount of the delay caused by the litigation. The company is raring to go to get these projects up and built, and we just need a little more time to get it done. And with that, we're happy to answer any questions.
Any questions? So, just so I understand, so the county intervened at the proper time in this one, as opposed to the first one?
Correct.
Okay. All right. Okay, so I move that we modify condition 3 of the CPCN to extend the construction commencement deadline to May 24, 2025, and the operational deadline to May 24, 2026 for the Biggs Ford Solar Center LLC solar generating project. Commissioner Schlesman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Mr. Chair,
Very much.
item number 14 is a request from Big Spring Solar LLC for a waiver of the operational deadline to begin commercial operations of its community solar project.
It's actually closer to Washington.
Good morning, Chair and Commissioners. Kenneth Albert again on behalf of staff. This item addresses a request by Big Spring Solar where they ask the Commission to delay by 6 months the deadline for Big Spring to commence operations at its community solar project. That would move the deadline from January 18th, 2024 to June 18th, 2024. Big Spring states that the project was accepted in the 4th year of the Commission's Community Solar Pilot Program under the open category, and it would be in the Potomac Edison Company service area. Big Spring has invested substantial capital in this project, and they've made a good faith effort to construct the project in a timely manner. However, they have experienced significant delays in acquiring major equipment and supply components that are needed to complete the project. We believe that Big Spring has demonstrated that the extension is justified and in the public interest, and therefore the staff recommends that the Commission grant the request by Big Spring to delay by 6 months the deadline for commencing operations at its community solar project.
Good morning, Mr. Chairman and Commissioners. Max Cook on behalf of Big Spring Solar LLC. I also have with me Mr. Luke Rappaport and Mr. Eli Landman with the company. We've reviewed staff's filing, and our only clarification is that this is a 5-month extension request to June 18th as opposed to 6. And with that, we're here to answer any questions from the Commission. Thank you.
Any questions from the commissioners? So I actually got one. This is a community solar project. So where are the customers? Because that's a fairly rural part of Washington County, if I remember right.
Yeah, I can answer that. So,
Sure.
hi, I'm Luke Rappaport from Big Spring Solar LLC. We have registered as a subscriber organization. We're working with a third party to get that subscribed. At this time, I believe we are close to 100% subscribed. It is a rural county, so it's obviously more of a challenge than some other community solar projects. But we have full confidence that it will be 100% subscribed.
But the customers will come from all across Washington County, or you?
That's right. So anywhere within the utility territory is generally the model. So if you are a Potomac Edison retail electricity user, you have the opportunity to subscribe to the project. It's not necessarily limited to users who are close to the actual solar project itself. It's more defined by the utility territory.
Okay. All right. Thanks. So any other questions? All right. So I move that we grant the request by Big Spring Solar to delay by 5 months the deadline for it to commence operations as a community solar project until June 18th, 2024. Commissioner Schlesman.
Aye.
Commissioner Barbe. Aye. Commissioner Richard.
Aye.
I vote aye.
Mr. Chair, item number 15 consists of revised tariff pages from Maryland Water Service, Inc. for the Pinto Water System.
Good morning, Mr. Chair and Commissioners. Alden Manka on behalf of staff. On August 10th, 2023, Maryland Water Service, Inc. filed revised tariff pages to revise the bulk purchased water rate for the Pinto Water System. This change is in response to the Allegheny County increasing its water supply rate on July 1st, 2023 from $7.03 per 1,000 gallons to $7.09 per 1,000 gallons. The company supplies water for the Pinto Water System by purchasing it from the Allegheny County Department of Public Works. The company's bulk purchased water rate charged to customers is the rate charged by Allegheny County with an additional 15% adjustment for unaccounted for water losses. Therefore, the current bulk purchased water rate is $8.08 per 1,000 gallons, and the new rate will be $8.15 per 1,000 gallons, for an increase of 7 cents per 1,000 gallons. The last time Maryland Water Service increased this rate was in 2021, when it increased from $7.38 per 1,000 gallons to $8.08 per 1,000 gallons. There are 940 customers who will be affected by this change, and their average bill impact will be an increase of 25 cents per month. The company is in good standing with the State Department of Assessments and Taxation and has no outstanding assessments with the Commission. Staff recommends the Commission accept the revised tariff for filing with an effective date of September 20th, 2023. Thank you, and I am available for questions.
Good morning again, Mr. Chairman and Commissioners. Max Cook on behalf of Maryland Water Service, Inc. We've reviewed staff's filing and have nothing further to add. We're here to answer any questions.
Any questions? So, if I remember right, this company files reports with the commission on a regular basis because of leakage issues with the system. Am I remembering that correctly, or?
Yes, Chairman. I believe that is with certain systems within under the company. Yes.
Okay. And it has to do with the topography of the service territory and I guess the age of the system, right?
That's correct.
Okay. But this is essentially just a direct pass-through of the increased price you're getting from Allegheny County.
Exactly right, Mr. Chairman.
All right, so I move we accept the tariff provisions for filing with an effective date of September 20, 2023. Commissioner Schlesman.
Aye.
Commissioner Barbe. Aye. Commissioner Richard.
Aye.
I vote aye.
Mr. Chair, item number 16 consists of revised tariff pages from the Potomac Electric Power Company.
Good morning, Chair and Commissioners. My name is Alessandro Lee here from Electricity Division. On August 3rd, 2023, PEPCO filed updates to its tariff sections relating to service connection fees for single-family homes and townhomes. The instant filing marks the second year that PEPCO is able to calculate rates based on actual service connection data instead of estimates, and also the second year where PEPCO calculates fees using an updated outlier removal method. In the instant case, the connection fees for the single-family homes did not change much, increasing by 1.6% for connections less than 75 feet, and between -3 and 1.6% for connections greater than 75 feet. The connection fees for townhouses changed by 3%, by 20% for those customers who installed their own conduit, and by 3% for customers who did not install their own conduit. Reviewing the filing, staff recommends the continued practice of calculating two separate fees for townhouse service connections, and also the practice of calculating two connection fees for single-family home service. Staff also recommends that the Commission continue to require PEPCO to file clean copies of their revised tariffs with updated language that outlines and defines how customers can qualify and apply for different connection fees. Finally, staff noted that PEPCO did not appear to remove outliers in their data for townhomes. And based on staff's analysis, staff recommends that PEPCO revise its tariff to reflect the new fees of $745.06 for customers who have installed their own conduit, and $3,115.67 for customers who have not installed their own conduit for townhouse service connections. I'm available for any questions.
Okay.
Good morning, Mr. Chairman, Commissioners. Jacob Auslander on behalf of the Maryland Office of People's Counsel. We filed a letter in support of staff's recommendations in this case. Last year, we had actually filed a letter raising some questions with staff's approach. The Commission did approve the use of staff's recommended methodology last year, and the parties have had a chance to meet since the matter was considered last year, and OPC is more comfortable with the methodology that staff is using for these fees. So we do support the application of their methodology this year, and we do support, in particular, the proposal by staff to remove the outliers for the townhome customers. And so I'm available for any questions that the Commission might have.
Okay. And so actually, before I go to the company, are you looking to speak on this? And if you are,
This is my subject matter expert.
I see. Okay, good enough. Then go right ahead. So.
Good morning, Mr. Chairman and Commissioners. Matthew Seegers for PEPCO. Appearing with me is Mr. John Caroma, who is our subject matter expert for this filing. We've reviewed, as a staff's analysis, we have nothing to add. We've also reviewed the OPC comments, and we have no objection to staff's recommendations in their buck sheet. So with that, we are available if you have any questions.
So, any questions? Okay. Well, in that case, I move that we accept the tariff provisions for filing as revised by staff in its comments dated September 11th, 2023, and we direct the company to remove the outliers consistently for both townhouses and single-family homes as delineated in staff's comments. Commissioner Sushman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Mr. Chair, item number 23 is revised tariff pages from the Potomac Edison Company.
And I see Mr. Trout's here.
Good morning again, Mr. Chair and Commissioners. Anson Justy on behalf of staff. On July 31st, 2023, Potomac Edison filed an update to its customer enrollment and information process flow section of its tariff to include energy assistance household indicator, bill cycle, and metered demand as customer information items that the company will provide when requested by electricity suppliers via EDI transaction. Like with the SMECO filing, this filing is in response to Senate Bill 31 or House Bill 397, which became effective July 1st, 2023, and prohibits a third-party retail supplier from offering to provide electricity or gas to households receiving energy assistance through a program administered by the Office of Home Energy Programs unless previously approved to do so by the Commission. The tariff language changes facilitate implementing this law. Staff and the company agreed to remove an inadvertent language duplication from the filing, and staff recommends the Commission accept the tariff as revised by staff with an effective date of September 20th, 2023. Thank you. I'm available for questions.
Mr. Trout.
Good morning, Chair Hoover, Commissioners. Jeffrey Trout, Counsel to Potomac Edison. We agree with staff's analysis and recommendation. If you have any questions, I'm here to answer them.
How bad was the traffic?
It was horrible. Extra 45 minutes waiting in a accident jam.
Oh, jeez. Well, glad you made it. So, any questions from the commissioners? So,
No.
okay. I move that we accept the tariff revisions for filing as revised by staff and its comments dated August 23rd, 2023, with an effective date of September 20, 2023. Commissioner Sushman.
Aye.
Commissioner Barbie.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Thank you.
Have a safe trip home.
Thank you.
Mr. Chair, item number 24 is the STRIDE status report of Columbia Gas of Maryland, Inc.
Good morning, Chair and Commissioners. Michael Dean on behalf of staff. Item 24 is a filing by Columbia Gas of Maryland of its 2023 semi-annual Strategic Infrastructure Development and Enhancement, or STRIDE, project status report. As provided for in Public Utilities Section 4-210, STRIDE is a program under which a gas company essentially replaces bare steel and other piping and services evaluated as being subject to failure, and is authorized to collect a portion of its cost through a surcharge, which Columbia Gas terms its Infrastructure Replacement and Improvement Surcharge. The Commission approved Columbia Gas STRIDE 2023 projects by a December 7, 2022 letter order, and the company filing reports its mid-year status of its work. Columbia Gas is working on 10 additional projects that were not included within the scope of the STRIDE work approved by the Commission, and included the status of these projects in its report. The staff comments detail its review of the status of the STRIDE work completed and funds expended for the STRIDE work. Columbia Gas anticipates the completion of all STRIDE projects approved by the Commission for 2023 by the end of this year. Staff recommends that the Commission note the filing. Mr. Carlos Acosta of the Pipeline Safety Group and representatives of the company are here to answer any questions.
So, actually, you want to make any comments? Or?
Mr. Chairman, Ted Gallagher on behalf of, and Commissioners, Ted Gallagher on behalf of Columbia Gas of Maryland. I have with me today Ken Fillion, who's a principal engineer with the company. I have no prepared comments, just to note that we agree with staff's recommendation and we are available for questions.
Any questions from the commissioners? So, just one for me. Looking at the list of projects, I take it they're all in Hagerstown, more or less? Just looking at the names on the projects.
Ken Fillion, good morning. Ken Fillion, Columbia Gas. I believe the vast majority are in the Cumberland area.
Oh, I see. But some of them are in Hagerstown, right?
Some, yes.
Okay. Any other questions? Okay. So, I move that we note the filing by Columbia Gas of Maryland. Commissioner Sushman.
Aye.
Commissioner Barbie.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Mr. Chair, item number 25 is the STRIDE status report of Washington Gas Light Company.
Good morning. My name is Additional Jayola. I'm with the Office of Engineering. This item addresses the report filed by Washington Gas on 1st of August 2023 on WGS progress in replacing gas mains and services pursuant to WGS implementation of its STRIDE. WGL filed on July 28, 2023 an update on the status of the projects in WGS CY 2023 project. The July 28 filing addresses projects that WGS said will be completed at the end of CY 22, but unfortunately it was carried over to 2023. In addition, the July filing consisted of removal of some projects, information on gas main and service lines, high-risk meter test, riser and steel gauge lines replacements, and transmission project list. WGL's reports include information on the projects on the utilities 2023 STRIDE project list including the status of each project, the forecasted actual and completion date, the length of pipe installed, and the number of services that were installed or replaced. In its July 28 filing, WGS said that it plans to replace 14.2 miles of main and approximately 3,760 affected services for a cost of approximately 85.7 million in calendar year 2023. WGS report also includes data on the variance between the forecasted cost and the actual cost of WGS STRIDE projects. Staff recommends that the Commission note WGL's filing.
Go ahead.
Good morning, Chairman Hoover and Commissioners. I'm John Dodge, appearing on behalf of Washington Gas. It's my first appearance in front of our new chairman and our two new commissioners. It's nice to meet you both in person. I have no prepared remarks either. We appreciate the staff's buck sheet, and I'm ready to answer any questions you may have.
Any questions? Oh, Commissioner Schlesman.
Yes, okay. So, Mr. Dodge, nice to meet you. And so, since it's your first time up, I have some questions for you. For STRIDE, so you're in your 5th year of the STRIDE 2 plan, is that correct?
That is correct.
Okay, and where are you in terms of completion of STRIDE projects for 2023?
I anticipated this question, so I'm
Okay,
looking
that's
down
fine.
to make sure I get the numbers.
And aren't you glad I asked it?
I am. It made my trip worth
Okay.
it, so thank you. We are projecting by the end of the year, at the end of STRIDE 2, we will have completed 94% of the services that we estimated, and about 70 or 71% of the main. This despite the challenges of the pandemic, supply chain disruptions, historically high inflation, and paving costs, which staff noted in the buck sheet, which are outside the company's control.
Okay, and so are you anticipating continuing the projects into 2024 until they're completed?
A two-part answer, if I may.
That's fine.
All of the planned services, that is the project list projects, will be completed by the end of this calendar year. There will be two types of carryover. Number one, some of the pipe complete, that is, the old pipe has been retired, the new pipe is actually in service carrying gas. Some of those have paving or restoration or bookkeeping to close them out. But the actual facilities, as I said, are used and useful. They're in service. Secondly, there are a couple of transmission projects which were not planned to be done at the end of this calendar year. Those two will be carried forward for completion in 2024.
Okay, but you haven't submitted a third STRIDE, have
Right.
you?
That we have submitted a plan.
Right.
And we will submit under Commission precedent, we'll submit our 2024 project list on November 1st of this year.
Okay, great. Thank you.
Any other questions? All right, with that, I move that we note the filing by Washington Gas Light Company. Commissioner Schlesman.
Aye.
Commissioner Barve. Aye. Commissioner Richard.
Aye.
I vote aye.
Mr. Chair, item number 26 is the STRIDE status report of Baltimore Gas and Electric Company.
Good morning, Chair Hoover. Good morning, Commissioners. Colby and Yanam on behalf of Commission staff. On August 1st, 2023, BGE submitted its STRIDE mid-year report to provide an update to the Commission on the status of projects approved by the Commission on December 2022 for recovery through the STRIDE surcharge. The company reports the following updates. For cast iron, the company has abandoned 13 miles. For bare steel, the company has abandoned 0.008 miles. For coated steel, the company has abandoned 1.4 miles. For plastic main, the company has abandoned 0.34 miles. The total main abandonment is 14.7 miles. For 3/4 inch pre-1970 high-pressure steel services, the company has replaced 1,138. For service replacement through BGE's Operation Pipeline Project, the company has replaced 2,196. The total service replacement is 3,334, and the total mains installed is 22 miles. BGE also reports increased challenges with scheduling and completion of its stride work due to customer resistance. This has led to less progress abandoning the gas services. Additionally, the company reports Baltimore City plumbing permit standard changes, and that has affected the replacement of the gas services. The combination of the increased outreach and the city's plumbing permitting processes are proving a challenge for the company and the stride gas service replacement work. These challenges have resulted in longer permitting processes, effectively doubling the time for the company to process the Baltimore City permit. Due to these ongoing issues, the company will not be able to complete the full scope of work approved by the Commission for 2023. Staff recommends the Commission to know the filing, and I'm available for any questions.
Yes, sir.
Good morning, Commissioners. Joel Michelle on behalf of BGE. We first like to thank staff for its review of our filing and accurate summary. I just wanted to take the opportunity to highlight 2 points that were made in our report. One is good news, and that's the fact that we have seen improvements in terms of supply chain. During our last updating to the Commission, we had reported that we were seeing significant delays in the procurement of materials. That has since improved. The bad news is that the rate at which we've been able to complete stride-related work has been negatively affected by the ongoing dispute surrounding the gas regulator placement. And you may be wondering why we're still talking about that issue given the Commission's September 5th order. In that order, you may remember that the Commission directed BGE to work with the parties to come up with a notice that would be provided to customers. One, informing them that we would be doing the work, installing the regulators, and two, informing them that they had an option in terms of where the regulator would be placed. And just to bring the Commission up to speed in terms of what the company has been doing to move that process along. That order, again, was issued on September 5th. On September 7th, the company provided a first draft notice to plaintiff's counsel. And the company's thinking was that we would work with plaintiff's counsel to come up with some agreed upon language and then bring that to OPC and staff to try to expedite the process. So again, on September 7th, we provided that first draft, and that draft was based on a prior conversation that we first had with plaintiff's counsel to try to talk about what he was expecting to see in that notice. And that first draft was meant to address all of what he requested. Plaintiff's counsel came back and made additional requested revisions that weren't included in our initial conversation. On September 7th, we provided a second draft to address his additional concerns. And unfortunately, as of today, we have not received feedback on the second draft that we've provided. Instead, what we've been told as of yesterday is that plaintiff's counsel would now like to have actually 3 different notices. And so we're continuing to try to reach resolution on that issue, but our concern is that we don't know how long it will take to get a resolution in terms of the language. And to date, we've lost about a quarter of the year in terms of our stride work. We have ceased installing for the most part installing regulators, so that we can fully comply with the commission's order. Unfortunately, in terms of the impact to customers, they're seeing real impacts, and I can briefly explain why that is. One, in terms of closing out a project, it involves us first replacing the outmoded main and then completing the service work, which really involves connecting smaller pipes to that main that connects to the customer's property. And on the end of that pipe would be the installation of the regulator. Well, we can't repave any of the streets or sidewalks until all that work is completed. Otherwise, we have to do a second round of excavation, drives the cost of the project up, and customers certainly wouldn't be happy with that. So as we speak today, there are a number of streets and sidewalks that have been dug up and have not been repaved because, again, we're trying to work through this process. We want to get back to doing the work, and any further guidance from the commission on this issue would be appreciated. I do have a few subject matter experts to the extent that the commission has questions. I have Kevin Nelson, Colin Tidings, and John Frayne here to answer any specific questions.
Let's deal with the first issue about the notice. And I don't want to, involuntarily draft somebody, but you said you've been dealing just with the counsel for the plaintiffs on a one-to-one basis. Maybe you might want to consider expanding it and actually bringing in the Office of People's Counsel. I mean, I understand he represents a segment of the customers, but they're also clients of the Office of People's Counsel, and maybe, through an involvement of them, they can help work out this arrangement regarding the what language goes into the notice and how many notices and things like that. I guess as an alternative, if that doesn't lead to some resolution quickly, then I guess come back here and we'll take a look at it and make a decision regarding it. I mean, we thought our goal in our order in September, earlier September, was to bring peace to this issue, and so I'd like to get it finally resolved. I know there's some other issues that you're involved with the plaintiffs, not directly affecting the installation of the regulators, but let's see if we can kind of get past this so you can get back on schedule. And obviously we understand that it doesn't make any sense for you to do work twice and the delays you're having from this, but let's see if we can try and get the ball moving forward. So.
Yeah, Chair Hoover, I appreciate that insight, and I would just put out there that our understanding is that plaintiff's counsel has suggested that either he will be or he has been in communication with the People's Counsel. I have no further information to corroborate that, but that has been his representation to the company.
Okay, well, that's...
Your Honor, Juliana Bell, Deputy People's Counsel. Mark Shebist, unfortunately, is ill today. He's been the attorney involved in this matter. I will note that OPC represents the interests of residential customers writ large.
Right.
It is not necessarily representing individual clients in this case. So our relationship with the clients of counsel for plaintiffs is a bit different. But I would imagine that Mr. Shebist would be happy to review suggested language. I do believe there's been some contact between counsel for plaintiffs and the Office of People's Counsel, but I personally do not know the extent of it.
Well, like I said, I didn't necessarily want to draft you into this, but if you can be helpful in moving it along, we appreciate it. So, any other, Commissioner Sushman?
Good morning, Mr. Michelle. Other than the replacement of the low pressure mains relating to the outdoor regulator issue, what other projects are not going to be completed by the end of this year? And I'm assuming those will just continue on into 2024.
Yeah, I think this is perfect opportunity to bring up our
Okay, thank
subject matter experts.
Thank you, Chairman, Commissioners. Kevin Nelson for BGE. So as we've read your order, it applies to all residential services. And since there are very few programs that are replacing low for low, it essentially applies to all of our replacement efforts system-wide, including those which are replacing high-pressure systems with, just newer high-pressure systems, which is one of our 2 STRIDE programs. To kind of summarize, there's Operation Pipeline, which replaces whole communities of low pressure with largely plastic higher pressure systems. And then there's a service replacement program, which replaces steel high pressure services from the 50s and 60s with plastic high pressure services. So our understanding and complying with the order is that it applies to all of those, and therefore we're doing this very little or no service replacement.
Okay, so what you're saying is until you get the notice issue resolved, you're pretty much stopped in terms of any additional STRIDE work for the remainder of the year?
That is an accurate representation.
Okay, all right, thank you.
Okay. Any other questions? Commissioner Richard.
Yeah, May, since you're here and we're talking about this regulator replacement, can you give me any updates on as far as trying to take care of some of the damage complaints of customers? I understand that there's a website that people are supposed to go to and insert their individual issues, and that the company will respond to that. How is that proceeding, and are our customers, happy with this process, at least from your representation?
Yes. So, Commissioner Richard, thanks for the question. I'm not sure I caught the beginning of your question. You said I heard something about customer complaints and.
Yeah, we're talking about the Operation Pipeline and the regulator replacements, but one of the issues, of course, is the concerns of customers about damage to their property. And how is that being addressed at this point? Do you have any representation as to where the company is and taking care of those complaints?
Yeah, what I can offer from the legal side, and my SME can chime in, is that in terms of any claims of damages, that is being dealt with in circuit court. There's a parallel proceeding. I know the commission had its own proceeding, but there's a parallel proceeding in the circuit court where we're actively litigating any claims of damages.
Okay, I was not. Okay, so that's all moved now to the courts and is no longer.
Yeah, that is my understanding.
Part of the company, and again, as I recall, there was a process the company had set up so that customers would go in and try to work directly with the company and your contractors. So that's all completely all moved now just to the courts.
I wouldn't say that. I think in terms of, as I understand your question, from a legal standpoint, for any claims of damages, that would be encompassed in the active litigation. I do know that we do have a claims procedure to the extent that there's overlap between any complaints from customers, and customers are making us aware of any of those claims. I mean, of those complaints through the claims procedure. Obviously, we would review those and deal with those on a case-by-case basis. But I would say it's, when we say damages, I can't sort of talk about it in the abstract. We need to know what the claim of damages are. So.
Okay, well, I ask you for a general, again, we're obviously reading about it and we heard about it, and the company said that they had a process to try to address the damages. So I'm not talking about the abstract, I'm just trying to get a sense of where you are right now. So
on that
this
issue,
is not abstract at all. This is
I'm addressing the question from a legal standpoint, and so when I hear damages, I'm thinking the active litigation.
Excuse me, I'm sorry to interrupt, but I'd like to just note that this matter is not on the agenda for today.
Okay.
Opposing counsel is not here, plaintiff's counsel is
Okay,
not
I wasn't trying to open up anything. I just wanted, since we were talking about operation, and then we're talking about cost and potential future cost, I'm just trying to understand, the scope of where we are. So
Absolutely.
if it'd be preferred we talk about this some other time, that's fine. Would you? Yeah.
Yeah, all right. We'll just hold it and see if there's further action on this. So. Any other questions? All right, with that, I move that we note the filing by Baltimore Gas and Electric. Commissioner Sussman.
Aye.
Commissioner Barve. Aye. Commissioner Richard.
Aye.
I vote aye.
Mr. Chair, item number 27 is a notification of assignment of contracts from U.S. Gas and Electric LLC, DBA, Maryland Gas and Electric, and Viridian Energy PA LLC.
Good morning, Chair and Commissioners. Andrew Schlicht on the behalf of staff. This item addresses a June 20th, 2023 filing by Viridian Energy PA LLC and U.S. Gas and Electric LLC, currently doing business under the name Maryland Gas and Electric. This filing notifies the Commission that Viridian has assigned its gas supply contracts for customers in the Washington Gas Light Company service territory to MDG&E. This transfer of customers took place on September 1st, 2023. There have been no complaints filed against Viridian with the Commission's Consumer Affairs Division beginning in 2018. However, 217 complaints were filed against MDG&E in the same time period. Significant to note is that there has been a sharp decline in complaints against MDG&E in the past 4 years. From a peak of 90 complaints filed in 2019, 6 complaints were filed in 2022, and 6 have been filed as of June this year. Staff recommends the Commission note the filing, and staff is available for questions.
Oh, actually, the Office of Appeals Council filed comments. Do you want to? Okay, yeah, go ahead. So, then I'll let you respond to both of them. So.
Good morning, Natalie Novak on behalf of the Maryland Office of People's Counsel. The Office of People's Counsel did file a letter on this matter. OPC is concerned that the customers who were transferred from Viridian to MDG&E were transferred from a company with a rather good history of customer complaints, 0 in the past 5 years, to a company with a more poor history of consumer protection allegations and violations. Due to these concerns, OPC is recommending that the Commission require MDG&E to provide enhanced monthly reports covering all complaints filed with MDG&E or CAD by any MDG&E customer, including the former Viridian customers. The reporting should be for a period of 24 months, and it should include the name of the customers who filed the complaints, a description of each complaint, and MDG&E's resolution of the complaint. OPC also thinks it's important to ensure that satisfactory legal recourse is available to these customers who were transferred from Viridian to MDG&E in regard to any liabilities that may come up current or present. In regard to those concerns, OPC recommends that the Commission should require Viridian or MDG&E to provide a copy of the assignment of contracts or other written documentation setting forth the terms and conditions pursuant to which Viridian's customer contracts were assigned to MDG&E. The documents should demonstrate whether the written assignment of natural gas contracts to MDG&E includes an assignment of all Viridian's rights and obligations associated with the contracts, including any liabilities or potential liabilities. OPC recommends that this information be filed with the Commission and copies be provided to OPC. And the Commission has authority to require or request these documents pursuant to COMAR 20.59.07b and its licensing authority under PUA Section 7-603 and 7-507. Requiring submission of these documents will allow the Commission to monitor the effects this assignment has had on the customers who were transferred from Viridian to MDG&E and ensure and determine whether any additional protections are needed to ensure that these customers have an avenue of legal recourse for all current and future liabilities. And I'm going to be available for questions. Thank you.
Okay. So.
Good morning, Chairman Commissioners. Eric Wallace here on behalf of Viridian and MDG&E. And I'm joined by Christina Montgomery, who's the Director of Policy for Vistra, which is the parent company that owns both of these entities and some other retail suppliers operating here in Maryland. And we appreciate staff's summary of the background and the notice here. I think for some additional context, we'd add that the reason for this assignment, this internal assignment between these two Vistra entities was it affects a small number of customers that were within the Washington Gas service territory, and the way that their systems are configured to interact with Washington Gas's systems, they had basically duplicative systems that were only serving a small number of customers. That they were, and MDG&E had a larger customer base, so they've transitioned these customers from Veridian over to MDG&E under the same contract terms, but to be able to be more efficient and no longer have the duplicative system operated under the Veridian brand. The total number of customers initially at the time that the company submitted the notice back in June was estimated to be about 225. I understand as of yesterday, it's a total of 203 customers that were actually transitioned on September 1st. And as staff noted, none of these customers have filed complaints. I'd like to address OPC's comments that were filed on Monday. The reporting obligation that they proposed, we think is not necessary here under these circumstances. And it's inconsistent with the way that the Commission has handled these kinds of assignments in the past. We were here for a similar assignment, intercompany assignment within the Vistra brands back in July. The Commission noted that transaction. There was not a reporting requirement imposed at that time. We're not aware of other instances where the Commission hasn't imposed a reporting requirement. Importantly for this context, it's the same people operating both of these brands within Vistra. So, the same folks that would be handling a complaint or a customer inquiry if the customer were still served under the Veridian brand are the same folks that would be addressing that under the MDG&E brand. And as staff noted, several years ago, back in 2019, is when Vistra acquired MDG&E, and they came in and they met with CAD and talked about the changes that they were going to be making to the business processes to try and get, kind of bring, the brand to align with Vistra's more robust processes and procedures to try and address some of the issues that the CAD was concerned about over the previous 4 years. And I think that the metrics that we've seen have shown a move in the right direction on the complaint numbers. But, and I think that's kind of shows that the changes that the company has made in this acquisition have been, moving things in the right direction. With respect to the assignment, the intercompany assignment request from OPC, the company, this was an internal transfer of these contracts. They don't have a formal contract or something disclaiming liability between one company and the other. From Vistra's perspective, if a customer files a complaint, the same folks would be addressing it. And actually, in this circumstance where it's all within the same company, they have the records from when they were under Brand A and under Brand B, and they have all that information to be able to promptly respond to customer inquiries and any CAD complaints that may come in. So it actually simplifies things. And in terms of who's responsible, I think our view is that for the period in which the customer was served under Veridian, the Veridian brand would be responsible, and for the period under which the company was served under MDG&E, MDG&E would be responsible. But they're both kind of, under the same envelope, and the same person and group of people would be handling a complaint with regard to either time period. So I think that makes things more efficient from, in terms of any issues that may come up down the line.
Any questions, Commissioner Schlesman?
So, good morning. Do you have sort of annual reporting that you do to CAD in terms of complaints or the complaint numbers that CAD has based on complaints that they've received? So, in other words, do you have reporting requirements that you have to meet monthly, annually, in terms of complaints?
There is not a commission reporting requirement under the supplier rules. That Are you talking about a report that would be filed with CAD or with the commission, or?
Right, right. Is there any and do you have a way of monitoring complaints that you receive?
The company tracks they have a customer relationship management system where they track their interactions with customers, inquiries, issues that come up, a process to see if this is a customer that has previously called. There's a platform that does that.
Okay, but once it goes to CAD, would you be aware of complaints that were made to CAD? Does CAD notify you? We've just received a complaint from a customer.
Yeah, that's exactly right. So the CAD process begins with the customer calling CAD or submitting an inquiry form online. That prompts a notification from CAD to the company that says, we've received this complaint from this customer, here's what they're saying. And in that request, or in that notification, they request a copy of the customer's contract, communications, relevant documentation, if there was an enrollment. Or in the case of, there's at least one example in the last couple of years where the customer wasn't actually enrolled. And so, it's a factual sort of exchange between CAD and the company depending on what the issue is.
Okay, but you have but within the company they have a place where it's noted that complaints are made, on a date. And this was sort of generally the substance of it. Yeah. I'm mostly just trying to get a sense of what you have, how onerous it would be for a period. I mean, maybe not monthly, but maybe bi-monthly or twice a year. How onerous would it be for you to provide the commission with information about complaints filed with CAD for customers of yours?
I mean, I think that's information that can be prepared and submitted, and CAD also already has that information because they are the ones that are receiving and processing those complaints, and they've communicated that with staff. Staff was reporting on those metrics in their report. So
yeah, well, I mean, CAD is pretty overworked. So I guess the question is, I mean, if you were to provide that information, it would actually be information that would be before us, so that we would know it, as opposed to going to CAD and trying to get the information. So I'm just trying to get a sense of how onerous it would be for the company if we were to have a reporting requirement for a year or two, just to kind of ensure that the customers that are being transferred over are not experiencing. I understand that they're going to be talking to the same people, but maybe to give them some comfort that we're at least following what's going on, to make sure that there aren't any issues.
I don't know the specifics of exactly how many man hours it would take or person hours.
I think you have a subject matter person there that maybe can help.
Thank you. Good morning. We haven't internally.
Actually, could you just state your name for the record?
Sorry, Christina Montgomery, Director of Regulatory Policy for Vistra Corp. We have not explored internally how many man hours it would take, but as Mr. Wallace had indicated, we do have a robust complaint tracking and reporting system. We do review that information internally periodically. I think the amount of man hours obviously relates to the frequency of the complaints. And then in this case, there were approximately 200 customers that were transferred to the new brand. So if we could limit it to the body of customers that were impacted by the assignment, that would obviously impact the number of man hours as well.
Okay, thank you. And so if we were to keep it to the 200 and then maybe not require monthly, but maybe bi-monthly, that will certainly reduce the amount of time that you would have to, or somebody in your company would have to commit to putting some report together.
Yes.
Okay, thank you.
Any other questions? Commissioner Richard.
Thank you, Chair Hoover. This may also be for Ms. Montgomery. I had a question just about Veridian itself. I know before I think your company acquired it, isn't it true that they had a kind of a unique marketing, I guess, procedure? Didn't they have like a family and friends networking type? And sometimes it was like congregations and businesses, and they set up special, I guess, contract relationships with their customers based on their I guess, success in signing customers up. Is that true? Is that how Veridian operated before you acquired it?
Yeah, Veridian uses a variety of sales channels at this point, but yes, you are correct.
Okay. And of these 225, do they have any of these sort of, I would just describe as unique contractual relationships that now you would be, I guess, acquiring?
Yeah, the assignment would not impact the contractual relationship at all. The terms and the conditions would remain in place. So the process by which they were acquired and the relationships that are existing would still be maintained even through the transfer to MDG&E.
Okay, that's all I wanted to know, because again, they were kind of a unique company in the way they do business. Are they still doing a networking, taking a networking approach to how they acquire customers?
Yeah, they're still an active supplier, yes.
Active and still doing the networking approach?
Mhm.
They are. Okay, great. Thank you. Thank you, Mr. Chair.
Mr. Barbe, any questions?
No questions. Thank you, Mr. Chairman.
Well, actually, so a couple questions from me. So Veridian is keeping its license and still going to be an active participant in the Maryland market. Is that correct?
Yeah, Veridian is going to continue to operate in the BGE service territory for natural gas. The change here is really around the specific, systems functionality and integration with WGL that they're no longer going to maintain. But I guess there's a separate system functionality that they use to interact with the BGE system, and they also, I believe, have an electric license and have customers on the electric side that are not part of this, the scope of this notice and this transfer.
And so hypothetically, if I was a Veridian customer and I'm now a Maryland Gas and Electric customer, if I decide I don't like that, can I just leave?
Yeah, the customer, under their contracts, I believe all of these customers have a termination provision that allows them to notice and leave the contract without any early termination fee. So we had, I mentioned at the beginning, like about 20 or so customers over the last couple of months have left from this group. And if additional customers, in response to the notice wanted to leave or switch to a different supplier, they could do so.
Okay. So, question for staff. Do you have an opinion about the reporting requests made by OPC? And either one of you can figure out which one wants to talk. So.
I don't think we've taken a position on that. I would say, Mr. Wallace mentioned, that this may not have been, that this approach was not taken back in the summer. I mean, the commission's duty is to justify its decisions. And if you, looking at the circumstances here, decide to impose a reporting requirement that you may not have imposed in somewhat similar circumstances 6 months ago, we think that as long as you give a justification for your decision, I don't think you're bound by what happened 6 months ago. Yes, consistency matters. I'm not saying precedent is irrelevant, but by the same token, you're looking at different circumstances, somewhat different players, and frankly, new commissioners. And that could allow you to, as long as you can feel it's justified. But no, staff has not taken a position on this with respect to these monthly reporting. We typically have not pushed these on in our buck sheets.
Anybody else want to offer anything before we?
I don't want to change, I don't want to move away from the monthly reporting request that OPC made, but I do want to reiterate OPC's concerns in regard to the liabilities between these two entities. The representatives from the company stated that they provided how they believe it might work out between if liabilities arise between Veridian and MDG&E. He said something like if it comes from the time they were a Veridian customer, it might be. I don't want to try to restate what he said, but OPC believes that these are two separate entities, and it's important that the relationship or the company's plans that were briefly stated before about how these liabilities will be treated in the future. If a customer is a part of a lawsuit or a liability arises when that customer was a Veridian customer at that time, MDG&E could say, well, they weren't our customer then. And I think OPC believes it's important that these The plans for assignment of these liabilities are produced to the commission and to OPC in writing.
Okay, so back to the company regarding this particular, the request you just discussed. I mean, how big a burden is that?
Well, I think that we don't have a formal, there's been no effort by the company to disclaim liability or transfer liability or there's really, from our perspective, the commission, these are both licensed entities. They'll continue to be licensed entities, and the commission can decide if there's an issue in the future how to resolve it and has authority over both of these entities in their licensing capacities. And nothing has happened between the companies to disclaim or limit the commission's ability to address those issues in the future. So we don't think that there's an issue here that needs to be resolved, and we don't have some sort of agreement transitioning liability to provide in response to this request from OPC, because it's a small group of customers. It was just an internal transfer within the company.
Okay, so I think what we're going to do is take a brief recess and then we'll come back with our decision. So, we'll come back at 11:40. Okay, so the motion that I'm going to make is that we will note the filing, but we are going to require Maryland Gas and Electric to file quarterly reports on the customers that were transferred from Viveron to Maryland Gas and Electric for the next 2 years. And with that, Commissioner Sushman.
Aye.
Commissioner Barve. Aye. Commissioner Richard.
Aye.
I vote aye.
Mr. Chair, item number 28 is an application from the Department of the Army for approval to construct a generation station.
Good morning, Chair and Commissioners. Michael Jang on behalf of staff. This item is a request from the Department of the Army for approval to construct 2 diesel generators rated at 2.5 megawatts each for a total of 5 megawatts in Aberdeen Proving Ground, Maryland. These generators use diesel as the primary fuel source and will only operate during an emergency. The Department of the Army plans to install these generators in October 2023. The Department of the Army provided a letter from BGE stating that it will not require a maintenance and operations agreement for the generators. Additionally, the Department of the Army sent a notice of its intent to construct the 2 generators to the governing officials representing the county in which the generating station will be located. Staff has not heard any opposition from the governing officials regarding the installation of these generators. A list of contacted officials can be seen in Appendix A attached to staff's buck sheet. As mentioned in the buck sheet, the Department of the Army is reminded that it must obtain all required local permits and authorizations and comply with all applicable zoning ordinances, land use requirements, and environmental regulations. Staff recommends that the Commission approve the application.
Good morning. My name is Hezur Khan. I represent the applicant, U.S. Army, Aberdeen Proving Ground, and we are installing these 2 generators for, our new facility, artificial intelligence, and they are already have been purchased and are available to be installed. We expect to operate them no more than 200 hours per year, and they will not be synchronized. We have received letter from, Baltimore Gas Electric. They have reviewed our design diagrams and all that. So they have no objection, and we appreciate, Mike's analysis and everything. We agree with it and request approval.
Any questions from the Commissioner?
Mr. Chairman?
Wait, well, actually, let me start with Commissioner
Okay.
Sushman and then come back.
Sure.
Okay. Good morning, Mr. Khan. So Aberdeen Proving Grounds, do you have any existing generation on site now?
We have generators, large number of them.
I wonder if you can come closer to the microphone.
Yeah.
Microphone. Good.
Okay, good.
Okay, thank you.
Yeah, we have large number of them at the base for different missions, and they are all emergency generators.
Okay, so in terms of generators, I mean, and the on-site generators are for use only on-site. You're not.
Correct.
Okay, and do you have a sense of the total number of megawatts on-site?
I mean, from these, we have
At Aberdeen.
we have almost
In total,
we don't know total, but we have almost 150.
about 150 megawatts.
No, 150 generators.
Oh, 150 generators.
And-
Do you have a sense of, in terms of megawatt?
Not compiled it, but it's already. We should be able to get it if needed.
Okay, so, and what kinds of generators are these? I guess the question is, do you have any renewable generators at the Aberdeen Proving Grounds now?
No.
Okay, so these are they all diesel generators?
They are diesel generators.
Okay, and anything other than diesel generators?
No, we don't have any. Turbine. We have turbine engine for cogeneration.
Wait, you have
turbine engine, turbine generators.
a carbon generator?
Turbine. TUR.
Oh, turbine.
Yeah, they
Right.
are roughly like 7.8 megawatt. and we
Okay.
generate electricity as well
So
as
it's a wind turbine you have?
not wind turbine, gas turbine.
Oh, you have a gas, okay. So you have, is combined cycle, single cycle?
Combined cycle, right?
Combined
Combined
cycle,
cycle.
okay. So you're thinking, let's just say,
And also, those are in Edgewood, like, Edgewood, Aberdeen, they are about 28 miles apart, right?
okay, okay.
Right.
So I'm assuming you're aware of the approach that the Department of Defense has taken in terms of trying to put more renewable generation on.
We're part of it.
Excuse
We are a part of it.
Okay,
Yeah.
okay, okay. So I took a look at the climate strategy that the U.S. Army's put out in 2022, and the Army is the most aggressive
Right.
of all of the branches in terms of trying to bring renewable generation on site and also trying to reduce the amount of greenhouse gases that you're emitting. And I'm just going to read objectives. So I know that this is not obligations on the on Defense Department facilities, but these are just the objectives. So install a microgrid on every installation by 2035, achieve on-site carbon-free power generation for Army critical missions on all installations by 2040, and provide 100% carbon pollution-free electricity for Army installation needs by 2030. So I guess I'm asking, when you made the decision to deploy these two diesel generators, did you think about the mission that the Defense Department has
We
put
have-
out, and have you thought about other kinds of generation? Even a microgrid that uses diesel would be more efficient than just diesel. So have you thought about other types of generating technologies before proposing these two diesel generators?
Not for this project. However, we are using a lot of, photovoltaic energy for a large number of our residential buildings.
Okay, so you're looking, so
We're already-
forward thinking, not for this,
Yes, correct.
but forward thinking, you're starting to think about
Correct.
ways to reduce your greenhouse, because putting 5 megawatts onto the Aberdeen Proving Grounds is actually going in the wrong direction
Yeah,
in terms of
we
greenhouse
like
gases.
solar very much. We like alternative very much.
Okay.
And we are for it.
Okay.
So anytime our army comes up with these, upgrades, whatever, we'll be the first one
Okay.
to use it.
Okay. All right, thank you.
Commissioner Barbe.
No, Commissioner Suchman anticipated my
Oh,
question.
okay. Commissioner Richard.
No questions.
One question. So, the letter that was sent to the executive secretary regarding this from July 12th, that was sent
Yes,
by
I have it
Sarah
up here.
Kristen. So, it discusses that these generators will always be mission critical. Now, given the fact that you're a Defense Department facility, does those words mean something beyond just, you need it to keep the lights on?
Well, let Jamie, he is actually the project.
Okay, sure,
group.
sure, yeah.
Can you tell us?
Good afternoon, or still morning? Yeah, good morning.
Yep.
James Laver, Armor Research Lab.
Mhm.
Yeah, these are mission critical because of their Department of Defense generators
Okay,
to back up supercomputers for AI
okay,
in case the power goes down.
I see.
So back to your solar question, I couldn't agree with you more. However, we're drawing 2,000 kilowatts just to run one supercomputer.
I see.
If that goes down, we need immediately. Now, I know it's not greenhouse effects, but environmentally speaking, we transfer to flywheels as opposed to UPSs.
Mhm.
So we get 20, 30 minutes for the generators to kick in, and we're good to go. And there are solar panels throughout
Yeah, they are
Aberdeen Proving Ground, or fields of them. And with this, you're talking 40 square foot, right? 40 square foot solar panel for 400 watts. You're talking over 200 solar panels just to be able to do that, and that's during a 5 to 6 hour day with the appropriate amount of sunlight.
Any other questions? All right. So with that, I move that we approve the application for the construction of the emergency generator station for Aberdeen Proving Grounds. Commissioner Sushman.
Aye.
Commissioner Barve.
Aye.
Commissioner Richard.
Aye.
I vote aye. And with that, I think we're adjourned.